Hi there, I'm Miko Nehman. I'm with Century 21 Hometown Realty.
And I'm April Hugh. I'm with Century 21 Hometown Realty.
We have Aaron Smith, attorney at law with Part 2, Trust Litigation. Welcome back.
Yeah, welcome back, Aaron.
It's good to be back.
Yeah.
I know, right?
So we just would like to ask you a few questions about the trust litigation and how that comes into play.
Well, trust litigation, sometimes it can't be avoided. I mean, there are times that you just, actually, I take that back. Any time that you gift everything equally to your children, most of the times there's not much trust litigation. A lot of the trust litigation comes in where it's an unequal distribution. And pretty much the main causes of trust litigation are an incapacitated settlor. So, dad has passed away, mom's still alive, but she's really getting infirmed and her capacity, she has dementia, and one of the kids who lives here takes her into an attorney to change the terms of the trust and leave everything to this child who's here, who's taking care of her.
Right.
That happens quite a bit.
Oh, quite a bit.
It does happen quite a bit. And that's a lot of times where you get the litigation coming in is that the family who doesn't live here alleges undue influence, and so you really, if someone were to come into my office and there is a question of capacity, that person, especially if they're gifting everything to one child over another. I'm not a doctor, so I can't really, technically determine incapacity, but I can tell. If there's someone who's very incapacitated, you can tell.
Right,
And,
you can tell.
You just won't do it.
Right.
But there are times when, the settlor has capacity and wants to give everything to one child, and it's their money and they have the right to do that. And if they have capacity, they can certainly do that.
Mm-hmm. So what happens if they don't sort it out and the person passes away, and then I'm sure you've gone to court,
Yes.
and so you're representing the...
I usually represent, I've represented both sides, the people contesting the trust and then the people who are fighting for the validity of the trust. It's very hard to contest a trust. It really is. It's difficult to prove incapacity because you have to prove that person didn't know what they were signing. And, or you could prove undue influence, and that's very difficult. Mm-hmm. So it's an uphill battle, and I get a lot of phone calls for claiming undue influence, but unless there's a lot of documentation showing that there's undue influence, or there are a lot of medical records that show that this person is incapacitated, oftentimes I just have to tell them that they really don't have, there's nothing they can do. Yeah. One of the things that you can do to prevent trust litigation is to do a certificate of independent review. And what that is, and it's a very simple way to avoid litigation. What it is they come to me to amend their trust, let's say, or create a trust. Okay. And they end up, and they want to give $200,000 to a caregiver. Okay, and because that caregiver has been with them for 15 years, and they're like family, and so they want to give them money.
Oh.
And so they come to me. They want to do that, and clearly the settlor has capacity, and he or she's they're in their right mind, and they just want to do that. Well, in the probate code, there's a presumption of undue influence when a caregiver is gifted money in a trust or in a will. And so to rebut that presumption, the easiest way to do it is the certificate of independent review. Okay. And what it is when you after you create the trust, or it can be before, but most of the time it's after you create the trust or the amendment and you sign it, that you're gifting a certain amount to a caregiver, you then go see another attorney. And that other attorney has you in their office, one-on-one, puts the document in front of you and explains the document and says, is this what you want? I mean, this is what this means. If that attorney is convinced that the person has capacity, is not under undue influence, that the person knows exactly what he or she is signing, then the attorney will sign a certificate of independent review, and that'll be part of this trust or trust amendment that has the caregiver as a beneficiary. And oftentimes, that is more than sufficient to rebut the presumption of undue influence. So it's a very simple way of avoiding trust litigation.
So, excuse me, you said earlier that it's hard to prove incapacity or not to, and then undo.
Undue influence?
Right. So then what do you end up in court over if you've...
Because oftentimes people do still file these actions. I mean, there's a lot of attorneys out there, and
so you're telling them there's nothing I can do, so then they go to the next attorney, and then you have to...
attorney will take it. And yeah, and there's attorneys who their whole practice focuses on trust litigation or litigation in general, and so they take these on, and I mean, it's a dogfight. I mean, it oftentimes it's years of litigation, and the only people who actually benefit are the attorneys.
There's nothing left.
There's nothing left.
There's nothing left.
And it's like just these families are just
Torn apart.
and just, it's
Never
just,
speak again.
Right.
It's
Right.
just,
And that's the worst part of my job, is having to see that, because it does happen.
I personally have been through several situations with...
clients and stuff. That
And
have gone through.
it was just, I felt so bad for this guy because he was trying to protect the mom, and then the sister got involved, and and I had to walk away because it was starting to hurt my heart, and it was getting brutal.
It does, and that's, my first 5 years of practice, I worked for a local firm before I went out on my own, and it was mostly litigation. And doing all litigation like that and just seeing the worst in people, it's one of the reasons why I went out on my own, because I just, I didn't want to have to do that the whole time. I want to be preventative. I want to be proactive and create documents that prevents that kind of thing to happen.
And that's right there is the prevention of the litigation.
Absolutely.
Get the
That's
trust,
the goal.
get the, have everything. Yeah.
Yep, that's the goal in this whole thing, is to avoid court at all costs.
Yeah.
That's great.
No court.
Now, I don't know if we talked about like the duties. I know this is kind of off topic from, this is actually the show before, but the whole executor, their duties, and the trustee, and...
So the trustee has owes a fiduciary duty to the beneficiaries. So there's certain things that they could invest in, and they can't invest in their startup company or something like that. They have to invest the funds in it's called a prudent investor standard. And so they owe a duty of impartiality to those beneficiaries. So, a lot of times there are trusts that are created where it says it gets distributed equally between 2 or 3 people, okay? And until that happens, there's a period of trust administration. And usually trust administration, when someone dies, takes 4 to 5 months. So, it's not overnight or anything like that, but it's generally quicker than probate, depending upon the assets. And during that time of administration, they have to treat all the beneficiaries equally. So if they give a preliminary distribution to one of the beneficiaries, they need to give a preliminary distribution to all of the beneficiaries. Otherwise, it could be considered a breach of fiduciary duty. So they have to be fair to all the beneficiaries.
Okay, that's
Yeah.
good to know.
And that happens a lot too, where there is a breach of fiduciary duty. I mean, that's more trust litigation, is where there's allegations of the trustee not being partial, or just recently there was a case where the trustee took, I don't know, I think it was $250,000 in trustee compensation. Clearly that is not given, and this was over like a year period. It was a very short period of time, and they didn't really earn that money. And so there's a breach of fiduciary duty there. And so there was litigation involving this trustee, who actually happened to be an attorney. And it was it was a sad deal, because it really, I think it kind of lessened to some degree people's trust in attorneys with this story. But yeah.
But typically, the executor or the trustee is typically compensated at the end for their duties.
Absolutely.
Is there a normal
Yeah, is there like a-
percentage?
I
think
was
it's like
curious.
1% or 2%.
Generally speaking, it's reasonable compensation, because if you give 1% and there's only 50,000 in the trust, sometimes it's not equal to amount of work that they do. Or if there's $3 million and they do they don't do very much, and they're getting $30,000. So what we usually do is we do a reasonable compensation clause in the trust. And what that means is you look at various factors. So you look at the complexity of the trust. You look at the time spent. That's a big one. Generally, if we're going to use time spent, I usually go $50 an hour for their time spent on that.
Okay.
But if it's more complex things, like let's say an accountant is trustee, the accountant can certainly charge more than $50 an hour to take care of those items.
Okay, all right.
And usually the trustee is not the attorney who prepares. Usually the attorney will not be the trustee. But every once, again though, if you do that, then there's a presumption of undue
I was going to
influence.
say, right. So you
And
just,
so then you have to do the certificate of independent review again to avoid anyone coming back later on and contesting that amendment in court.
Okay, all right.
So.
whew, I got a lot of information.
That
here
was good,
going in.
huh?
Yeah,
Yeah.
yeah. But you made it very simple. You kind of,
Yeah,
You know,
go
just-
get the form and
yeah.
avoid any problems. And I think that parents, when they, draft trusts, they don't ever want any sort of problem to come up later. So
No, that's the goal, is to, that's why they're making this effort to do this, is to avoid the problems.
Exactly.
And I would say, one of the problems of having these trusts is, way back in the day, the AB trust was the most popular trust, because the exclusion amount to avoid inheritance tax was so low that you wanted to be able to use both of the spouses' exclusion amount from inheritance tax.
Okay.
But now that exclusion amount is $11.7 million. So if you have over $11.7 million, then you'll have to pay inheritance tax. But unless you have that much, there's no inheritance tax that's going to be owed.
Okay.
So, but a lot of these older trusts that were created are still AB trusts, and they take away the control of the surviving spouse. The surviving spouse can't amend the entire trust, and so I get a lot of people who come in who we get rid of that AB trust and just create a trust where it goes to the surviving spouse. And then when the surviving spouse dies, it goes to
Okay, so you kind of just start over.
You start over,
Yeah.
unless it's a good trust, and we can just say everything goes to the survivor's trust. Nothing goes into this other irrevocable trust.
So now, if there's you have a trust, and then you, upon your death, you want like your oldest kid to be the executor, even though they all three have, equal, but you have the one kid, in charge, I guess.
as a trustee.
Is a trustee. Okay, so where am I going with this? I just, because I've seen siblings with these real estate deals and have these issues with the one in charge and try to dispute with the one now do you get a lot of that?
I get phone calls saying, I want to be a part of this sale. I want to be able to make this choice.
Okay.
And I tell them, sorry, your mom and dad appointed your older brother, so it's their choice. And as long as the terms are fair, there's nothing you can do about it. And you know, if you're going to be mad at someone, be mad at your parents. But usually that's the way it works.
Okay, just
I know, and you and I have both been through so many interesting situations. It's like, it's very interesting.
It is. I'm sure on your end you see it all too, and that's when they call me. And
So, Aaron, so how can people reach you? What is your phone number?
so my phone number is 805-739-5500. Okay.
Another great amount of information, and we appreciate you being here.
Thank you for having me.
Thank you so much,
Yeah,
Aaron.
it's my pleasure.
All right.
If you have any other further questions, I can be reached at 805-714-8124.
And my number is 805-878-5056. Thanks for watching.
See you soon. To see more information, go ahead and click on that button, and you can reach me at 805-714-8124.
And my number is 805-878-5056.
Thanks for watching.
Yeah, we'll see you soon.
Bye.